Hello everybody, I'm Ulugbek. Today we're going to talk about copyrights and arts. So first thing first, uh, we need to consider the significance of intellectual property law as it is important to businesses, and also violations of others' rights can be costly even if done by an employee of the company. It is also equally important to understand the base of ownership of trademarks, patents, and copyrights as business property and assets. Understanding resource and legal uses available under the law, understanding when employers own employees' works are also essential. So why this is important? If, if we look at the current issues, then we can understand that pirating and illegal downloading of music and movies are included in copyrights. Borrowing images from the internet, making copies for the classroom, business liability for customer, and employee infringements. Because of the ease of obtaining rights and infringement on rights, this is becoming an even greater issue today due to the myth about what constitutes a violation. Violations being inadvertent or due to misinformation. Expanded employer business liability for violations by customers and employees. So as you can see, this is the iconic label is a property right. This is an intangible property right composed of 6 separate rights. Infringement is often difficult to define, detect, deter, and enforce. Identifying ownership, single owner, joint owner, businesses, employers. Rights may be transferred, bought, sold, rented through assignments and licenses. Rights may be exclusive or non-exclusive, written or not. Rights may be inherited or given in wills and trusts. Intellectual property is property, whether it's like tangible or intangible. It is important to have respect for property rights. Alright, now overlap or intersection with intellectual property laws, we have patents, trademarks. So patents cover systems, processes, discoveries, stronger protection, 14 to 20 years of protection maybe. New, obvious, and useful, requires registration. Patent attorneys generally expensive. On the other hand, trademarks protects words, slogans, phrases, logos, symbols, etc. that identify products in the marketplace. Unlimited time established through actual use or registration, likelihood of confusion, cyber-squatting, delusion may be registered with state and federal. Alright, do you own any copyright rights? Acquiring copyrights is easy. You can do it without even being aware of it. So does anyone have a cell phone with pictures? You acquired copyright ownership in those. Alright, now, acquiring copyright rights, original works of authorship fixed in any tangible medium of expression, original, so they are original and fixed. Element 1. So in order to be an item, some minimal degree of creativity, the requisite level of creativity is extremely low, even a slight amount will suffice. A creative spark, so these are the elements we need to consider if that product is original. Also owes its origin, not copied. Phone books, the white pages alphabetical order is not enough. Maps based on facts unless the cities were imaginary or false. There is no suite of the borough doctrine in copyright. Element 2, fixed. Some samples of works not fixed. Choreographic works not notated or recorded. Improvisational speeches not recorded. Performance not written or recorded. Broadcasts if not being simultaneously recorded. Pictures written or writing a poem in the sand. Skywriting, jazz improvisations, improvisational political skills. Independent creation. A legal doctrine in which two or more may own copyright in essentially identical work because of the ease of getting copyright rights. This may occur often. Unlike patents, each cannot stop the others from using the other's work. They must not have copied or known the other work. Ideas are not protected under copyright. Copyright doesn't protect ideas, only the expression of ideas. They may not be protectable under patent law. The particular design or expression of the idea may be protected. So the copyright rights, what do you get? reproduce the work in copies, prepare derivatives, distribute copies to the public for sale, rental, lease, or lending, perform publicly, display publicly, and that's it. Alright, as you can see, copyright notice. And the first thing we need to have is the symbol. See, right this one is like a symbol, like C1. The year of publication, right here, 2012, and the name of the copyright owner, Willow Misty Parks. So for works created after January 1st, 1978, one author, life of the author plus 70 years, joint work, life of last surviving author plus 70 years, anonymous works made for hire, 95 years from publication or 120 years from creation, whichever is first. Alright, copyright registration. Why bother? Registration is not required to acquire rights. Prerequisite to being able to file an infringement lawsuit in court establishes a public record. Timely registration may permit statutory damages up to $150,000 plus attorney fees and court costs. Evidentiary value of certificate of registration. Rebuttable presumption that copyright is valid shifts burden of proof to dependent to prove invalid. Who owns copyright? Three types of ownership. One, author, creator. Once it's fixed and original, the individual creator owns it. For the life of the creator plus 70 years, joint or co-authors, creators, all contributors on those of the last owner plus 70 years. Works made for hire. If made by an employer, the employer business owns it. 95 to 120 years depends on the publication. Alright, so these are the areas of copyrights we have to consider and talk about. Thank you very much.